So the assault weapon ban challenge that we've all been waiting for is now going to be considered by the Supreme Court in just 2 weeks. So let's talk about what's happening in this critical case. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. They're pro-freedom, pro-America, pro-2A. They have amazing supplements, and right now they're going to be running a ton of Black Friday deals as well. So check them out using the links down below if you're interested. And then also, if you use my personal links down below and you order over $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be talking about a very important assault weapon ban challenge that is currently seeking Supreme Court review and is going to be considered by the Supreme Court in just 2 weeks. The briefs in this case have been submitted, and now the Supreme Court has distributed this case for conference, and it's going to happen in just 2 weeks. This critical case is Snope versus Brown, and it's a challenge to the Maryland ban on so-called assault weapons. You may remember that recently the 4th Circuit en banc panel upheld the state of Maryland's ban on so-called assault weapons using the incorrect military use test. This case now for the second time has made its way to the Supreme Court, and now the Supreme Court has set conference for this case and they're going to consider it. However, the state and the anti-gunners are trying to avoid this by, every means possible. They tried to stall this case, and now they are arguing in their briefs that this rifle ban in Maryland does not violate the Second Amendment. They argue that it's in line with the Bruen decision, and they are also arguing that this case and this issue is not yet ripe for Supreme Court review. Now, for those not aware, this case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore banning them in the state of Maryland. This ban was challenged in a Maryland federal district court. However, the case was dismissed because the lower court had to stick with some prior precedent in the 4th Circuit. The 4th Circuit had already reviewed the Maryland ban, and the 4th Circuit en banc panel prior in a case called Colby had ruled that this Maryland ban is constitutional. Now, the dismissal in the Snope case was then appealed to the 4th Circuit, and the 4th Circuit once again upheld the dismissal. Then the case went to the Supreme Court back in 2022 seeking review on this issue. What ended up happening in the Snope case prior, was called Brown. This case was put on hold. It was waiting for the Supreme Court to rule in the Bruen case, and once the Supreme Court issued their Bruen decision, the Bianchi case was granted, vacated, and remanded back down to the 4th Circuit for a new decision in light of what the Supreme Court said in Bruen. This case was then opened back up in the 4th Circuit, and a 3-judge panel held oral arguments in this case, but then this case sat dormant. No decision was issued for 13 months. Then suddenly out of nowhere, the 4th Circuit en banc panel showed an interest in this. They took the case out of the hands of the 3-judge panel, and they issued their own decision. In that decision, the majority of the 4th Circuit stated that the assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Now, there was dissent out of the 4th Circuit. There was a dissent from Judge Richardson, who was then joined by Judge Niemeyer, Agee, Quattlebaum, and Rushing. Those dissents in the 4th Circuit stated that the majority decides that Maryland's ban is perfectly consistent with the Second Amendment, but the majority's rationale disregards the Second Amendment and controlling precedent. Rather than considering the amendment's plain text, the majority sidesteps it altogether and concocts a threshold inquiry divorced from the right's historic scope. Now, that 4th Circuit en banc panel decision was not shocking at all, but now what's good about it is it teed up a final merits review that is now going to the Supreme Court. The Supreme Court finally has a case in front of it that's on the final merits, and it deals with whether or not a rifle ban entirely in a state is constitutional or not. Now, initially, the state of Maryland was trying to stall this case and avoid Supreme Court review by asking for multiple extensions to respond to this petition. The Supreme Court recently did give them some partial extensions, but the state was still ordered to file their response by November 12th so that this case could be distributed to conference before the end of this year. Maryland did file their response briefs to the Supreme Court, and they tried to frame the issues in this case in a very interesting way. They stated that should this court decline to grant certiorari to consider the constitutionality of Maryland's assault weapons ban, where 1, that ban is consistent with the court's recognition in Heller that jurisdictions may ban weapons that are most useful in military service, M16 rifles and the like. 2, the 4th Circuit faithfully applied Bruen to conclude that Maryland's law is consistent with this nation's historical tradition of regulating those weapons that were invented for offensive purposes and were ultimately proven to pose exceptional dangers to innocent civilians. And third, there is no need to resolve a conflict among the lower courts. The state of Maryland also argued that the Supreme Court's Bruin decision left intact the whole statement that M16 rifles and the like can be banned by states, and they're trying to lean heavily on that to say that what they are doing is lawful. They also stated that in accordance with Bruin's command, the Court of Appeals examined the relevant historical traditions, and they concluded that even if the weapons are protected under the text of the Second Amendment, Maryland's law is constitutional because it falls squarely within the strong tradition of regulating excessively dangerous weapons once it becomes clear that they are exacting an inordinate toll on public safety and societal well-being. In the response brief, Maryland's main position is that this law does not violate the Second Amendment because they believe AR-15s are one and the same with M16s, which we all know they are not. And they argue because of that, they are dangerous and unusual arms only suitable for military purposes. They also take the hardline approach that because of that, these are not arms protected by the text of the Second Amendment. They then conclude their response brief by saying that even if the Supreme Court believes that potentially this law violates the Second Amendment, they should not grant review to this case because there's not yet a circuit split on whether or not assault weapon bans are unconstitutional. So they're saying you should wait for this to develop more in the lower courts before you grant review to this issue. Now, in response to Maryland's arguments, the plaintiff here through their counsel, Ray, I actually got to work with Ray when I was over at FPC, amazing attorney. They filed a brief in response to this arguing that yes, the Supreme Court should grant review to this case. They state in their response brief that 30 years ago, this court described the semi-automatic AR-15 rifle as a civilian, commonplace, generally available, and traditionally lawful firearm. 16 years ago, this court confirmed that the Second Amendment protects the right of individual citizens to possess firearms that are in common use for lawful purposes. In the intervening 16 years, semi-automatic rifles have continued to be commonly available. And there they cite directly to Sotomayor's statement in the Cargill case saying that AR-15s are in common use. And they also state to the ATF's acknowledgement in the frames and receivers rule. They go on to state that this therefore should be an easy case. The Second Amendment protects common firearms. Semi-automatic rifles like the AR-15 are among the most common firearms in the nation. Therefore, bans on semi-automatic rifles like the AR-15 violate the Second Amendment. Yet incredibly, in the 16 years since Heller, every single court of appeals to consider the question has concluded that such bans are constitutional, employing a variety of tests that are uniform only in their failure to adhere to the principles established by this court. Maryland asked this court to deny certiorari to allow even more time for percolation, but enough is enough. The lower courts have proven themselves incapable of following Heller's clear guidance, and this court should intervene without delay. So this case is now entering a very critical stage. The Supreme Court has now distributed the case for conference on December 13th. What that means is that the court will get together and decide if they want to grant review to this case. Now, for the Supreme Court to grant review, to grant cert to this case, you would need at least 4 justices that want to take this case. There maybe is enough core with Alito, Thomas, Kavanaugh, and Gorsuch, but also you would have to take into consideration, well, if we grant review to this case, do we have enough numbers to rule the way that we want? And there's always the question mark out there with Chief Justice Roberts and then also Amy Coney Barrett. So it will be interesting to see how this develops. This is a huge battle that's currently developing and a significant conference that's going to happen just in 2 weeks. So that's what's currently happening in this critical assault weapon ban case that everyone should be keeping their eyes on. Usually after the conference, when that happens the following week in the order list, we would get some sort of indication whether or not they're going to grant review, deny review, or push it out to a future conference. So as we get more information, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.